Ancestral land sold in the middle of a case. Is the buyer safe or stuck? The High Court's Lis Pendens ruling made everything clear. Imagine this. It's your grandfather's land. Land filled with memories, where crops once grew and around which silent family tension has existed for years. You go to court because you want everything to be clearly settled on paper. The case is ongoing, dates after dates are being given, and then one day you find out that a part of that very land has been quietly sold, without informing you, without asking you. Now fear sets in. Has my case become meaningless? Will a new buyer walk in and complicate the entire fight? And this is where curiosity begins. Who does the law stand with in such situations? This exact question has now been answered very clearly by a recent judgment of the Andhra Pradesh High Court. The judgment delivered on the 8th of January 2026 relates to an ancestral agricultural land in Andhra Pradesh, but its impact is not limited to just one family. This ruling is important for millions of Indians whose lands are still jointly owned, where disputes over shares continue, and where relatives often make a move during the case itself. In this matter, there were 3 brothers, a few relatives, and in between appeared a buyer who probably thought that once a registered sale deed was done, everything was safe. But the story of the law runs much deeper than that. The entire case revolves around nearly 3 acres of ancestral agricultural land in Annamaya district of Andhra Pradesh. 3 brothers claimed this land as theirs and wanted their relatives to stay away from it. Their argument was that this was family property and that they were its rightful owners. For this reason, they filed a suit in court seeking a permanent injunction, so that the relatives could be restrained from interfering with the land. The case began, dates were fixed, and everything seemed routine. But in the meantime, a twist came that shook the entire case. One of the relatives against whom the case was filed claimed that he owned a 50% share in that ancestral land, and out of this alleged share, he sold a portion of the land on the 5th of November 2018 to an outsider, Mr. Reddy. A registered sale deed was executed. His name was entered in the property records. On paper, a new owner had now emerged. At first, the relatives completely denied the sale. It was said that the brothers had fabricated a false story. But when the documents were placed before the court, one of the relatives admitted that he had indeed sold the land. However, he also claimed that he sold only from his own 50% share and not even an inch from the brother's portion. In legal terms, this was a very clever argument. I sold what was mine, not yours. Now, the brothers faced a new concern. They argued that since a part of the land had now gone into the name of a third person, it was necessary to make him a party to the ongoing case. Their fear was clear. If the buyer was not included, he might later claim that he was never heard, and therefore the judgment would not apply to him. Because of this concern, the brothers requested the court to implead Mr. Reddy as a defendant. The matter first went before the trial court. There, the brothers received a setback. The court held that even if the sale had taken place, it occurred while the case over the land was already pending. In such situations, an old and very strong legal principle applies: Lis Pendens. The trial court clearly stated that the buyer would automatically be bound by the final outcome of the case, whether or not he was made a party. Therefore, there was no need to implead him as a defendant. The brothers challenged this decision before the Andhra Pradesh High Court. The hope was that the High Court might allow the buyer to be added, so that there would be no ambiguity. But the High Court fully upheld the decision of the lower court, and this is where the judgment became a major legal precedent. The High Court stated in very clear terms that when a property is under dispute in court, and during that time a third person purchases the property, it is not mandatory to make that purchaser a party to the case. The reason is simple. The law already assumes that such a buyer purchases the property at his own risk. His rights are automatically subject to the final decision of the court. This is where understanding the principle of lis pendens becomes extremely important. Lis pendens is a Latin term that means a dispute pending before a court. In Indian law, this principle is codified under Section 52 of the Transfer of Property Act. Its essence is very clear. If a lawsuit regarding a property is pending in court, and during that period someone buys that property, the transaction may be legally valid, but it will remain subject to the final judgment of the court. In simple words, you may buy the land, but you also buy the risk along with it. If the court later holds that the seller had no right over the land at all, the buyer cannot argue, I didn't know, or I was not a party to the case. The law has already warned him in advance. The High Court emphasized exactly this point in its judgment. The court said that by not making the buyer a party, no prejudice is caused to the original plaintiffs. This is because the buyer's claim is in any case bound by the final decision of the court. If the brothers succeed in proving their ownership, the buyer's sale deed will automatically lose its strength. He cannot rely on that deed to challenge the court's decision. This ruling is especially significant because in India, it is quite common for disputed properties to be sold during litigation, either to weaken the case or to create pressure. Then the new buyer steps in and demands to be heard, to be made a party, and on that pretext the case drags on for years. The principle of lis pendens exists precisely to prevent this tactic. The court also clarified that a sale made during litigation does not automatically become void. The sale deed is not cancelled immediately, but its value is conditional. It depends entirely on what the court ultimately decides. If the seller loses the case, the buyer loses as well. This judgment also sends a strong message to those who plan to buy land that is already under dispute. Getting your name entered at the registration office, having your name recorded in official records. None of this is final protection. If you buy land while a case is pending, you must assume that you are entirely at the mercy of the court's final decision. The same logic applied in the case of the three brothers. The High Court held that the core dispute, who actually owns the land, can be decided even without making the buyer a party. The buyer's rights will automatically be determined by that decision. Therefore, there is no legal necessity to implead him as a defendant. This judgment is not just a technical legal point. It is deeply connected to social reality. In India, ancestral lands often remain jointly owned for generations. Brothers, cousins, uncles, everyone lays a claim. When such disputes reach court, the most common trick is, let's sell it and see later. This High Court ruling puts a clear check on such tactics. It also shows that courts are now firm about not allowing cases to be unnecessarily prolonged. If every new buyer were made a party, even a simple ownership dispute would never end. Lis Pendens is a powerful tool to prevent exactly this kind of chaos. In the end, the essence of this judgment is very simple. If a case over your land is pending and a relative or co-owner sells it during the litigation, there is no need to panic. The law ensures that such a buyer is automatically bound by the court's final decision. And if you are the buyer, this ruling is a clear warning. Buying disputed land without thorough legal due diligence means you are not just buying land, you are buying a long legal battle.
If our video has taught you something new, do not forget to like and share this video so that this information can reach others as well. Your likes and shares are a source of inspiration for us. If you have any questions or suggestions, please let us know in the comments. It will be our honor to answer your questions and listen to suggestions. And yes, if you like our content, subscribe to the channel and press the bell icon so that you stay connected with every new story. Thank you. GRT Business YouTube channel sources, news from various news agencies, opinion polls and other public sources. We try to ensure that every report and summary is accurate and verified, but we are not responsible for any dispute or error. Our aim is only to provide you with accurate information.